Florida is one of the most active rental markets in the country, and its lease termination framework reflects a landlord-friendly approach with clear statutory procedures. The governing law is found in the Florida Residential Landlord and Tenant Act, Florida Statutes. Chapter 83, Part 2, and it provides a well-organized set of rules that every Florida landlord needs to know. Let's start with no-cause termination. For month-to-month tenancies, Florida requires either party to provide at least 15 days written notice before the end of any monthly period. That's right, just 15 days. This is one of the shorter no-cause notice periods in the country and gives Florida landlords significant flexibility to end month-to-month arrangements quickly. So if rent is due on the 1st and you want the tenancy to end on the last day of the current month, you need to deliver notice by the 15th of that month. For fixed-term leases, the lease expires at the end of the agreed term without additional notice required unless the lease specifies otherwise. If the tenant remains after the term expires and the landlord accepts rent, the tenancy converts to a month-to-month arrangement subject to the 15-day notice requirement. Landlords who don't want this conversion should send clear written notice before the lease expires and stop accepting rent after the term ends. For week-to-week tenancies, Florida requires 7 days' notice from either party. For quarter-to-quarter tenancies, 30 days' notice is required. And for year-to-year tenancies, 60 days' notice is required. Florida's statute is specific about matching the notice period to the type of tenancy, so make sure you know which category your arrangement falls under. Now let's cover termination for cause. For non-payment of rent, Florida requires the landlord to provide a 3-day notice before filing for eviction. Under Section 83.56, the landlord must deliver a written notice giving the tenant 3 business days, excluding weekends, legal holidays, and the day the notice is delivered, to pay the full amount of rent owed or vacate the premises. If the tenant pays within the 3-day window, the notice is void. If the tenant doesn't pay or vacate, the landlord can file an eviction action in county court. The distinction between calendar days and business days is critical in Florida. 3 business days can easily translate to 5 or more calendar days when weekends and holidays are factored in. Landlords who miscalculate the timeline and file too early will have their cases dismissed. Florida courts are strict about this requirement. Here's an important detail about Florida's 3-day notice. It must contain specific statutory language. The notice must state the amount of rent owed and must include language substantially similar to what the statute prescribes, informing the tenant that they must pay the rent or surrender the premises. Using incorrect language or omitting required information can invalidate the notice. Many Florida landlords use pre-printed forms that comply with the statutory requirements, which is strongly recommended. Florida also has a specific rule about accepting partial payment during the 3-day notice period. If the landlord accepts partial payment after delivering the 3-day notice, the notice may be waived, meaning the landlord would need to start the process over with a new notice. To avoid this, Florida landlords should not accept any rent payment after the 3-day notice is served unless they intend to cancel the eviction. For lease violations other than non-payment, Florida uses a 7-day notice to cure framework for curable violations and a 7-day unconditional notice for non-curable violations. Under Section 83.56, if the violation is one that can be corrected, the landlord must provide written notice giving the tenant 7 days to cure the breach. If the tenant corrects the violation within 7 days, the notice is void. For violations that are not curable, meaning violations so severe that they cannot be corrected, or that by their nature destroy the landlord-tenant relationship, the landlord can deliver a 7-day unconditional notice to vacate. The tenant has no opportunity to cure and must leave within 7 days. Examples of non-curable violations include intentional destruction of the property, unauthorized assignment of the lease, and unreasonable disturbances that continue after previous warnings. Here's where Florida has an important provision for repeated violations. If a tenant cures a violation within the 7-day cure period, but then commits the same violation again within 12 months, the landlord can deliver a 7-day unconditional notice to vacate. The notice must reference the prior violation and cure, and must state that the same conduct has recurred. Because the tenant already had an opportunity to cure and the violation was repeated, no additional cure period is required. This 12-month look-back provision is one of the most practical tools available to Florida landlords. For criminal activity, including drug offenses, violent crimes, and other illegal conduct on the premises, Florida allows the landlord to proceed with a 7-day unconditional notice. The landlord doesn't need to provide a cure period for criminal conduct, and the court can prioritize the eviction hearing when the circumstances involve health or safety threats. Florida also has specific provisions addressing situations where a tenant's conduct poses an immediate threat. Under certain circumstances, the landlord can seek a temporary injunction to remove the tenant before the full eviction process is completed. This emergency remedy is available when waiting for the standard process would create an unreasonable risk to other tenants or the property. The eviction process in Florida goes through the county court. The landlord files a complaint for eviction after the applicable notice period has expired. The court issues a summons, and the tenant has 5 business days to respond. If the tenant doesn't respond within 5 days, the landlord can request a default judgment, and in many cases, the court will enter judgment for possession relatively quickly. If the tenant does file a response, the case proceeds to a hearing or trial. Florida courts schedule eviction hearings on varying timelines depending on the county's caseload. In high-volume counties like Miami-Dade, Broward, Orange, and Hillsborough, the process can take longer due to heavy court calendars. In smaller counties, hearings may be scheduled more quickly. Here's something unique about Florida's eviction process. If the tenant files a response and wants to remain in possession during the proceedings, they must deposit the amount of rent claimed in the complaint into the court registry. Under Section 83-232, the tenant must make this deposit within 5 days of filing their response. If the tenant fails to make the deposit, the landlord can move for an immediate default judgment. This rent deposit requirement is one of the most powerful tools in Florida's eviction framework. It prevents tenants from using the court process to live rent-free during the pendency of the case. If the court rules in the landlord's favor, a final judgment for possession is entered. The clerk then issues a writ of possession, and the sheriff posts a 24-hour notice on the property. After 24 hours, the sheriff carries out the physical eviction. The overall timeline from filing to removal varies significantly by county. In some Florida counties, the process can be completed in 3 to 4 weeks for uncontested cases. In Miami-Dade and other high-volume counties, the timeline may be longer. Florida does not have a statutory right of redemption once the eviction has been filed. Unlike states where the tenant can pay at any point during the proceedings and stop the eviction, Florida's framework moves forward once the notice period expires and the case is filed. The court may exercise discretion in certain situations, but there's no automatic right to cure by paying late once the complaint has been served. On the tenant's side, Florida provides several grounds for early termination. If the landlord fails to maintain the property in habitable condition, as we covered in our Florida habitability video, the tenant can provide written notice under Section 83.56 and allow the landlord 7 days to make the repair. If the landlord doesn't act within 7 days, the tenant can terminate the rental agreement. Active duty military members are protected by the Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. Florida has an enormous military presence, including Naval Station Mayport, Naval Air Station Jacksonville, MacDill Air Force Base, Eglin Air Force Base, Patrick Space Force Base, Enos Pensacola, Homestead Air Reserve Base, and numerous other installations, making this provision relevant to a very large number of tenants across the state. Florida provides early termination rights for victims of domestic violence, dating violence, sexual violence, and stalking under Section 83.683. A tenant who is a victim can terminate the lease by providing written notice along with documentation, including a valid injunction for protection, a police report filed within the preceding 60 days, or a written statement from a qualified professional. The tenant must provide at least 30 days' notice before the termination date. The landlord cannot charge early termination fees, and the tenant's liability is limited to rent through the termination date. Florida's domestic violence termination provision also includes a lock change right. The tenant can request that the landlord change the locks within 24 hours of the request, if the perpetrator is not on the lease. The landlord can charge the tenant for the actual cost of the lock change. Florida also provides early termination for tenants who are 62 years of age or older and need to relocate due to health conditions, though this is typically governed by the terms of the lease rather than a specific statutory provision. Florida strictly prohibits self-help evictions. Under Section 83-67, a landlord who prevents the tenant from gaining reasonable access to the premises by changing locks, shutting off utilities, removing doors or windows, or other means is subject to liability for actual and consequential damages and court costs. The tenant can also recover the cost of reasonable alternate housing. Florida courts enforce this prohibition, and landlords who engage in self-help face both financial liability and potential contempt proceedings. Florida's anti-retaliation protections are found in Section 83.64. Landlords cannot discriminatorily increase rent, decrease services, or file for eviction in retaliation for a tenant exercising any right under the Landlord-Tenant Act, including complaining about habitability issues, contacting code enforcement, or participating in a tenant's organization. The tenant can raise retaliation as a defense in eviction proceedings, and if the court finds retaliation, the landlord can be liable for damages and attorney's fees. One practical consideration for Florida landlords: the state's hurricane season creates unique challenges for lease termination. From June through November, Florida rental properties face the risk of significant storm damage. If a property is substantially damaged by a hurricane or other natural disaster, the lease may be terminated under the doctrine of impossibility or frustration of purpose. Under Section 8363, if the premises are damaged or destroyed so that the enjoyment of the premises is substantially impaired, the tenant can terminate the rental agreement and vacate within 30 days. The tenant is only liable for rent through the date of termination. Landlords should have clear lease provisions addressing what happens in the event of storm damage, including the allocation of responsibilities and the process for determining whether the damage is substantial enough to terminate the lease. Florida's insurance requirements for rental properties are also closely tied to the termination process. Landlords who carry adequate property insurance can rebuild and re-rent more quickly after a storm. Those without sufficient coverage may face extended vacancies and disputes with tenants over the habitability of damaged units. Florida requires landlords to return the security deposit within 15 days of the tenant vacating if no deductions are being made, or within 30 days if the landlord intends to make deductions. If the landlord intends to claim deductions, they must send the tenant written notice by certified mail within 30 days specifying the reason for the deductions. If the landlord fails to send this notice within 30 days, they forfeit the right to impose any claim on the deposit. The tenant then has 15 days to object to the deductions. Florida's security deposit statute is detailed and specific, and failure to follow the exact procedures can result in the landlord losing the right to retain any portion of the deposit. Florida also requires landlords to hold the security deposit in either a separate non-interest-bearing account, an interest-bearing account where the tenant receives interest, or a surety bond. The landlord must notify the tenant within 30 days of receiving the deposit of how the deposit is being held, including the name and address of the depository. Failure to provide this notification can affect the landlord's ability to claim deductions later. For the complete guide to Florida lease termination laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for every state in our series.